I present to you the interview series titled LGBT Rights in India. In this series, we interview individuals involved in the decriminalization of Section 377 of the Indian Penal Code that made homosexuality a crime in India. This series is presented to you in collaboration between JURIST Legal News and Commentary based out of Pittsburgh, United States and Humsafar Trust, India through the Likho Fellowship. Sit back, relax and enjoy this interview.
Good morning, good afternoon, and good evening to our viewers around the globe. I am Sambhav Sharma, the India correspondent and journalist for JURIST based in New Delhi. Today with us, we have Professor Arvind Narrain. Professor Narrain is a professor at the School of Policy and Governance at Azim Premji University. Sir is an alumnus of the National Law School of India University, and Sir pursued his master's from the University of Warwick as a Chevening scholar. Sir has also authored and edited books such as Law Like Love and Breathing Life into the Constitution. We welcome you here with us today, sir.
Thank you.
So proceeding with the discussion, at the very outset, I understand that you are an academic, you are a researcher and a lawyer. You're dedicating your life and your scholarship to queer rights. And what I would primarily want to know from you is how has your journey been so far? I'm sure in a country like India where homosexuality has only very recently been decriminalized. What were the hurdles that you faced and how did you get about beginning your journey?
Yeah, thanks, Sambhav, for that question. The provision which one is talking about is Section 377 of the Indian Penal Code, which criminalizes what it calls carnal intercourse against the order of nature. It's the legal provision which really is criminalizes or targets or persecutes same-sex activity in the not just in the Indian context, but in the broader global ex-British colonies. In fact, if you look at if you go from India to Singapore to Malaysia to Ghana to Trinidad to Guyana, literally to places in the Pacific, which are all former British colonies. What you'll find is that this particular provision is there as what Justice Kirby called Britain's least lovely colonial export. If there are any lovely colonial exports, I don't know, but this is definitely not a lovely export, as it were. And your question is, how did the battle against this particular provision begin? It's 1860s when the law came into force, and as you know, 1950s when the Indian Constitution comes into force. And the interesting point, of course, is the Constitution has embedded in it, obviously, the fundamental rights chapter with the promise of equality. The preamble in particular stresses the concept of dignity. There is the preambular emphasis on the liberty of expression, right? All of this is there. But 1950 to 2008, there has been, it's never seen fit that the Indian Constitution applies to the LGBT citizens of India. And it only tells you one thing, that the rights are always accrue to people by virtue of struggle. Rights don't fall from the sky. Rights are not a gift of anybody. You get your rights if you struggle for your rights. Of course, what we had going for us is a constitutional framework, which allowed for rights to be read within the constitutional provisions on equality, non-discrimination, and the right to live with dignity. And again, I think I think part of the way I would describe, I wouldn't see myself as primarily an academic in your description. We fundamentally see ourselves as social legal activists who use the law as a tool for social transformation. So the Constitution is very important to us. The issue of people's struggle is very important to us. And really, it's a question of how do these two come together? Because I'm not a believer that the changes happen by lawyering in the courts alone. I'm not a believer that changes don't happen through the use of the law either. I think law is very important, but the law has to be in the context of a social movement or a social struggle. And that's really the journey which I will very briefly try and tell you now about. We began in 1997 actually in the National Law School with a conference on gay rights, and that in a sense provided the impetus really, because I mean if you look at it, I mean look at most of the lawyers we'll be speaking to, most of them have had some relationship to the National Law School, and so it's very interesting that one institution played a key role as far as the histories or trajectories of so many people in the movement of in the struggle were concerned. And really, our beginning point was this: we saw the fact that Section 377 criminalized LGBT people's right to existence, and we said it's very important to fight against this particular provision. But again, the point being that you can think about it this way. Somehow think about it this way: if a provision of the Indian Penal Code goes tomorrow, will the world be a better place? Assuming you are super smart, come up with a brilliant legal strategy, you argue some fine nuance which the judge gets, and tomorrow a provision goes, will the world be a better place? That's a question we asked ourselves. And our answer is very clear, that this is a battle really about changing people's minds and hearts, changing social perceptions, ensuring a society in which parents accept their LGBT children, which societies no accept. That's the struggle we have. So it's very clear for us. The law is a tool, is a way of engineering this form of social transformation. That's the way we solve law. Which means then, as far as we are concerned, 377, the battle against 377 has to be a battle which is fought in the courts. It has to be a battle which has been fought on the streets. It has to be a battle which is fought in society. So you see the battle against the two coming together. And I'll really put it this way. I'll say that the battle against 377 began in terms of outside the courts. It began in the court of broadly put public opinion. It began in the ways of generating an opinion against this law. And we were successful in that, to the extent that there was an article in a popular, I think India Today, and one time by a journalist called Kaveri Babzai, she called 377 a metaphor for all that is wrong with our sexual universe. Right? And there's broader acknowledgement that it is not okay to criminalize the diversity of forms of sexual expression, because that hits at the root of autonomy, hits at the root of dignity. That's the argument which was made in a wider public forum. We were lucky that argument was picked up when the petition was filed in 2001 by NAS Foundation. It had its own trajectory and journey over 17 years. But in 2009, the Delhi High Court, in the watershed judgment, recognized that 377 violates the right to privacy, dignity, and equality of LGBT persons. I'll just make one point about maybe 2 points about the judgment, and then leave it to you to ask a question. Otherwise, I think I'll be going on and on. And maybe that's not the framework. That's not the framework you're looking at, right?
No, it's just a conversation. I'm loving everything that you're saying. So please tell us more.
Fine. Okay, so I'll just make 1 point about the 2 points about the Delhi High Court judgment. When we began the arguments before the Delhi High Court, we began by referencing, in the sense, just Mr. Anand Grover, who's the other person you must speak to, the lawyer for Lawyers Collective and who represented NAS Foundation in the Delhi High Court. And we represented the group called Voices Against 377, filed an intervention in the Delhi High Court. But he made the argument, citing the Wolfenden Committee report. The Wolfenden Committee report it's a report which made the recommendation for decriminalizing same-sex sexual conduct in the UK context. And the argument they used is a very, very interesting line. They said, morality, in brief and crude terms, is not the law's business. Translate that in another way. It basically says, what you do in the privacy of your bedroom is your business. Is that good enough for you, Sambhav? LGBT rights?
I mean, I feel it's still a little vague. If I were to say, I mean, yes, definitely. But I think one of the few reservations that I have with the way the law is evolving in India with regards to queer rights and this is just personally my belief, is that it has to be expressly laid down. Just to sort of sway away for a moment, when in Navdeep Singh Johar, the court said that, okay, these are the rights that are due to this community. At the same time, when the court was silent on same-sex marriages, I mean, that's something that I feel that should be the court's prerogative to actually expressly hold, so that, I mean, once and for all, the community actually gets what they deserve, is what I feel.
Okay, we'll just take one point from what you said. I'll take it because you jumped several steps. You jumped to 2018.
Right.
I'll take you back to 2006 or 5 when the argument, 7 when the arguments happened. Anyway, see, the arguments made by us at that time were based on the beginning arguments on the Wilfred and Committee report that brief and crude terms, area of private immorality or morality, which is not the law's business. What is so fascinating is Justice Shah and Justice Mulligar, much like what you're putting forward now, seem to feel that was inadequate. They were like, why are we talking about this? I mean, we need to go several steps in front, Right. And after that, I think it's interesting that, I mean, the response of Justice Shah to Shamdavan's argument, who represented Voices Against 377, where he made the point that, so the beautiful way of putting it, he said, yes, sexuality is something which travels with you wherever you go. It's a part of who you are. It is who you are when you see yourself in the morning in the mirror. It's who you are about where you go. It's about the way it influences the way you interact with people. It's a part of your fundamental right to dignity, right? So, in a sense, what happened through the arguments is the sexuality was taken outside the sphere of the bedroom and became an intimate part of people's ways of being and people's existence in the judge's perception. So if you read Nas, the important recognition in Nas is that we're not talking about the right to privacy as zonal privacy. We're not talking about the right to do whatever you choose to do within the confines of your bedroom. We're recognizing a much more public, a much more expansive right, in which your sexuality becomes integral to your personal, in the sense that dignity, going back to the constitutional framework, is fundamentally, in the judge's interpretation, about your right to make decisions about your intimate life. Who you choose to be with is not the law's business. Who you choose to be with defines who you are. It's a part of that choice making which is integral to the idea of personhood itself. So they saw it within that frame. So they really took it way, way, way beyond what we had expected. We began with the expectation that, if they decriminalize, we'd be happy. And suddenly you had this really magical duo, in a sense, where an imagination is broad-ranging. The second important point they did is, of course, expansive notion of privacy, expansive and express and dignity. And the other important thing they did, the justices, is they got the issue of sexuality within the language of the Constitution by invoking two key figures. They invoked Jawaharlal Nehru to make the point that inclusivity is the heart of the Indian Constitution. And you're not recognizing LGBT rights as just as another grouping who's deserving of rights or whatever. You're recognizing because that's what your Constitution mandates. Your Constitution doesn't say discriminate against people on any ground. And so if your mandate of a Constitution, with the heart of your Constitution is inclusivity, you have to recognize the right to dignity and personhood of the LGBT community. The second thinker they invoked was Ambedkar, Baba Sahib Ambedkar, and they quoted his particular, what he says on constitutional morality in the Constituent Assembly debates, where he makes the point. He says that constitutional morality is not a natural sentiment. Our people have yet to learn it. We have to cultivate it. And he goes on to say that democracy in India is top dressing on a soil which is essentially undemocratic. So here we get to the heart of why the Nas Foundation judgment is so important, and the heart of the recognition of where the challenge really lies. When you say democracy in India is a top dressing on a soil which is essentially undemocratic, you're pointing out to a very uncomfortable truth. You're pointing out to the truth that Indian society has within it the biases and prejudices which makes it impossible for LGBTI people to live with dignity, and which confines, constrains, constricts them, and suffocates LGBT people within societal institutions like family and marriage. That's the point which the recognition of constitutional morality moves us towards. So if that is the case, then the responsibility of the judiciary, in this case, in Justice Shah's interpretation, is really open up that space in terms of the law for the recognition of something which society may not yet have recognized. So the judges are several steps ahead of society. They're saying in this case that they don't say this in direct terms, but through quoting constitutional morality, they are making the point that regardless of what society thinks, we believe that the mandate of the Constitution is to recognize the right to dignity and personhood to LGBT persons, so we will recognize it. So that's the route down which they go in 2009. I'll just take you maybe to two other landmarks, and then I'll leave it to you to ask any further questions that you may have. Of course, if you say that the judges were 2 steps ahead of society, society is bound to have some form of backlash against what the judges say, and which is precisely what happened. Which is, you had in 2000 and post the judgment, immediately post the judgment, within 7 days, you had appeals filed against, especially petitions filed against the judgment, asking for its stay by Hindu, Muslim, and Christian religious groups. In the end, there were 15 appeals filed by a range of groups on all sides of the religious divide, as it were. Which, of course, was a moment of great stress, because then, suddenly, even as the most progressive judge in the Supreme Court, you have 15 people from different religious traditions breathing down your neck, saying that, this is wrong, this is wrong, this is wrong. What does the judge do? At the least, your responsibility is to ensure the judge has support for that particular viewpoint. At the moment in time, there's, of course, NAS Foundation, there's Voice Against Race and Understanding. So we said, let's think about this. What do we do? And then we came up with the plan that we should have interventions filed supporting the NAS Foundation judgment by covering a couple of key aspects. And those key aspects were, one was in terms of, one intervention was filed by 19 parents of LGBT persons. And they made the point that it's 377, which really destroys family values or attacks family values, because parents said that our family value is going to have open conversations with our children. Our family value is that we want the integrity of a family to be protected. We don't want our kids to be arrested when they're meeting other persons, etc., etc. We don't have the Damocles sword or Section 377 hanging over the heads of our children. So 377 against family values. And I'll get back to my point on why this is a social legal struggle. The parents' intervention was absolutely, absolutely vital for the media role that it played, because we were very conscious. We said that it's a defeat. It's an opportunity. The petitions filed with the opposing party is an opportunity for you to get more people involved in this particular conversation, and that's absolutely vital. If you don't have more conversation on this, if you don't change the way society thinks on this, then your struggle, your victory might be of a fairly limited consequence as it were. So anyway, so the point is that if you again go back to NDTV, and maybe if you're doing this, actually you should do this. If you're playing this as a video, as it were, play a small, at this moment, you play a small extract from an NDTV interview with parents of LGBT persons, where you have these 3 parents sitting with their 3 children, right? And speaking about 377. And the parents, in a sense, are looking very traditional, like Indian mothers, with a bindi and a sari and stuff like that. And yet they're saying the very radical things about why they support their children, right? And again, you think of the social impact of mothers speaking out has, or a transformative impact of mothers speaking out as compared to me speaking out, or compared to an activist speaking out, etc. So that reached, I think, a fairly large audience. So we were very pleased with the fact that we were able to generate a wider public opinion outside the courts, not in the courts, but outside the courts, using the courts, using the framework of the courts. That is one petition, where one more by the mental health professionals and one more by teachers of LGBT persons, and one by Sham Benegal filed intervention as well. So all of this basically communicate some support. Maybe 15 is a lot. We have 5 people at least on our side supporting the particular petition. Anyway, so all this happens. We we're going ahead with creating this kind of wider awareness in society, etc. And of course, 2013 we get the judgment by Justice Singhvi and Justice Mukhopadhyay, and all the lawyers speak to will tell you that during the hearings, Justice Singhvi and Justice Mukhopadhyay were not not sympathetic, and it proved very, very difficult to move them at all. There were affidavits filed by queer people which were read before them, affidavits of parents of LGBT persons. All of this was placed before them, but none of this seemed to have any impact on their mindsets. They seem to have completely made up their mind. It's an open question. Do you think anything could have changed the minds of Justice Singhvi? But there's one question. Second question, if it changed their minds, what is the kind of judgment should have got? I wager, if by chance we had managed to push them, the best case judgment, if you read all Justice Singhvi's judgments, best case judgment would have been a judgment that would say, read down 377, following the Delhi High Court, full stop. That would have been the nature of the judgment. You would not got an expansive, wide-ranging judgment as which you got in 2018. And you wanted marriage. In 2000, if you had got a judgment just Singhvi and Mukhopadhyay, you would have been happy to get, you should have been happy to get decriminalization. That is what you would have been happy with. You know, I mean, as narrowly framed as possible is what you got, with zero language to aid your future struggles. Now, 2018, you have a great judgment, which will be the base of any marriage petition litigation in time going forward. You have a fantastic base. And Chandrachud's opinion in particular is verging. It's verging on the borderline. So saying that, you know, you come to me, I will give you equality of balance.
Right. I'll ask a follow-up there. So firstly, I just want to comment, I just feel that it's spectacular how this entire movement, if I may call it so, originated from a single question of, will the world be a better place if this provision doesn't exist? And I feel the floodgates is sort of opened in terms of the teachers, the parents, and you come to realize how oppressed people were before a few actually considered to raise this question, and how voiceless people were. And in those terms, I feel that this was obviously, I wouldn't even call it the need of the hour. I feel we were a few decades too late to raise this question. But now that you've brought the point of same-sex marriage and how the courts have interpreted it, now we've understood the judiciary's perspective. We've understood the perspective of the activists. The one perspective that's still, I mean, I wouldn't call it, it's in a gray area because it's quite clear. But the one perspective that I personally do not agree with is that of the government. Now the center has gone the whole 9 yards to ensure that same-sex marriage is not recognized in India as per law. In fact, only yesterday I was reading the proceedings in the Abhijit Iyer matter, where Mr. Mehta for the government stated how marriage in essence is only supposed to exist between heterosexual couples. And when Miss Nandi also argued how, you know, I mean, the provisions that are applicable in the matter are in fact gender neutral, and how Mr. Kirpal said that the natural consequence of the Navteej Singh Johar decision is legalization of same-sex marriages as well. However, and the question is for you, how do you feel that, and if at all, the understanding of the government and these institutions, has it evolved ever since the first step was taken towards it? Or do you feel that, I mean, still, I mean, till now, I mean, it's sort of a roadblock to actually recognizing. And just to add to that, I feel, I mean, the courts have been very clear when it comes to marital rights as well. In fact, in Shafeen Jahan versus Ashokan, I think the Supreme Court very clearly said that the right to choose your partner, whether outside the marriage or inside the marriage, is completely the prerogative of the person. It's their exclusive domain and the state cannot interfere. Then we also have right to privacy, be recognized as a fundamental right. After all of these developments, why is it that the government is still so critical of it, and has there been any change?
You know, this is a great question. It's a really fantastic question. And let me try and answer it by looking at, I mean, my remembrance of the way the government's, what is the government's position from 2000 onwards, right? And over the last 20, 21 years, and 17 years of the legal struggle at least. You know? And initially when the 2001, the petition was filed, the then I think it was then Congress government filed an affidavit. Or was the BJP government? I don't remember. Congress government. Anyway, you should check this. Please check this one point. In 2004, the affidavit filed by which government was it, right? And the affidavit had one line. They said that there are no gays and lesbians in India. I was like, what? Did you actually say that? There are no gays and lesbians in India. And they went on to say that criminal law should run concurrent with societal morality and should protect societal morality. Two basic points they made. But you know what was interesting was when they made that submission that there are no gays and lesbians in India. You speak to again, the other person who should speak to is actually Vivek Dhawan, who was part of the litigation since 2000 onwards, and he told me that in court at that moment, I forget which judge it was, basically said, Faisal, what are you saying? There are pride marches which are going on. This was before the pride, but he said the marches which are going on in the cities in India. I mean, he must have meant some protest or demonstration because prides began in 2008 as it were. But anyway, so that's the point he made. So which again tells you that what happens in society is very important. It gives support to what judges think. It can give support to what judges think and really solidify their particular viewpoint. Anyway, that was the viewpoint in 2004, 2005. Arguments with the Delhi High Court, the ASG, I'm forgetting his name, Mr. Malhotra, Mr. Malhotra, Mr. P.P. Malhotra, I think was his name. Anyway, so he made, I think, some of the most offensive submissions, which I've had the honor of hearing on the LGBT issue, and it went something like this. He said, Your Honor, these gays, they want to use the anus for the activities. Anus is meant for excretion, Your Honor. They want to use it for other kinds of activities. So that's the tenor of the submission, right? And we were there in court. We were listening to this as counsel of voice against dissent, and we did not, in a famous way, we did not dignify his submissions with a response, right? I mean, so we said that that's the nature of the world, and we had to wait till we get our judgment, as it were. No media reporting on the kind of, you see, again, you look at a book on the Alternative Law Forum website. It's called The Right That Dares to Speak Its Name, right? And you look at the arguments for Delhi High Court, you get whatever I'm saying, it's there, it's documented in great detail, what Mr. Malhotra said. Okay, so in 2013, right? Before 2013, before Justice Singhvi and Mukherjee's court, Mr. Malhotra came. He made the same argument. I kid you not, ditto, word to word. He said the anus is a place meant for excretion. They want to do a sexual activity.
And in fact, just to add to that, I mean, talking about submissions and affidavits by the government, only last year, I feel in October, the government made a submission of how the family values, or the exact word that used, but the customary family unit, as we recognize in India, only recognizes a heterosexual male as a husband and a heterosexual woman as a wife, and there can be no other alternative. So the rigidity and the logical fallacy that I personally feel exists in the stance of the government and has existed forever. I just feel that in today's times, where so much has evolved, where the courts have exclusively, expressly held that this is indeed a right, what makes the government sort of fall back on arguments?
I'm getting to your question. Because in 2012, in the hearings before the Supreme Court, the same submissions were made by Mr. Malhotra. But what was the change which I noticed is we saw the submissions and we didn't take it seriously. We said, that's life. That's the way they think of us. They continue to think of us like this. They continue to speak like this. I mean, that's the way it is. And you'll continue to fight this. And there was an uproar in the media. The media was like, went to town saying, how come these kind of submissions are being made by the government of India, shocking submissions, etc., etc. That was the language of tenor of the media reported. Then Mr. Chidambaram responds to that, and they send the then Solicitor General, Mr. Vanavati, to come and represent, right? And then he, in effect, withdraws the submissions made by the ASG, and then he makes fresh submissions. What were his submissions? His submissions are that, that we stand with the Delhi High Court judgment. We go with what the Delhi High Court judgment is saying. We do not contest the Delhi High Court judgment. the government of India, this is again for your reference point, there's no such thing, abstract thing as the government of India. This is the Congress UPA administration. Did not oppose in the Supreme Court. So this was Singhvi, Justice Singhvi's in particular, what he had, I don't understand. Because I mean, when the government of India is standing with the Delhi High Court judgment, he still went ahead. They still went ahead and gave a judgment, regardless of what the government of India said. And in fact, he was shocked. He was shocked by Mr. Vanavati's submission. He said, Mr. Vanavati, you made a different submission in the Delhi High Court. Mr. Vanavati, again, going back to your point, he made a very interesting, his submission was very interesting. He said, Your Honor, we were educated by the Delhi High Court judgment. We learned through the Delhi High Court judgment. That is why our position today has changed.
But then do you think that after that, because it's also been like 6 years.
Wait. Let me just go on with the story. You just you hold on to your horses. I'll give you a chance to come in once I'm done with it, because otherwise I think I'll be repeating myself. Right. So the post the where was I?
We're talking about the submissions of the Delhi High Court and
no, we passed the Delhi High Court. We're in the Supreme Court, 2013. And post Mr. Vanavati's submissions, Justice Singhvi goes on, right, to hold that goes on and gives the judgment which he does, which is of course as becomes described as a bad day for law and law. But we're not getting into that part of it. We're just following the trajectory of the government, right? And this by now it's of course the government, the UPA administration goes on to file a review petition, which again is rejected by the bench of Justice Dattu and Justice Mukhopadhyay. And then the other petitioners go on to file a curative petition, right? Anyway, and then finally all of this culminates in the fresh petition which Navtej files, and that's what is the government of India's position on the Navtej petition. That's what I want to get to. That's what I want to draw your attention to. And there, by now it's a BJP administration or NDA administration, right? And the position they take in court is they say that they reluctantly concede the fact that they may not have a problem with this understanding. They're not going to oppose. But then they're very clear. They say that any further rights we will not concede. This is an issue of decriminalization, full stop. That is it. Nothing more. That's the line they take. That's the line they take through and through. And if you look at the final Navtej judgment, I think an important Justice Nariman's judgment where he says that the central government has the responsibility to basically to popularize the judgment using all the media at their disposal, including training programs with police officers and government officials, etc. None of which the union government has done, and we have not pressurized them to do. They've kept completely silent on that particular point. So the point I'm trying to get to is there is a difference between the position taken by the UPA government, between the position taken by left parties, between the position taken by a range of other progressive parties, and the NDA government. NDA government is at most, they've conceded the issue of decriminalization, nothing more. They told you that. They told you that in 2018. Why is surprised now that they're opposing marriage question? Of course they'll oppose it. They've told you that. They're not saying they're educated by the Delhi High Court judgment. If anything, they've gone backwards. And the point I'm getting to is, I'll end with this, and then you can take it up from there, is that I don't think there's a way forward unless there's a way in which different social groups come together and you're making this case that this kind of a social policing, moral policing, this kind of a lack of respect for the autonomy of different groups and communities, including LGBT communities, including women, from the rigors of moral policing needs to be fought. And this government's stand is indicative of a larger conservative disposition. I mean, the LGBTQ community hasn't realized it, but I think this what you're describing as the position taken in the Delhi High Court is a wake-up call. They're telling you very clearly what their position is. They're saying that you want more rights? We're not going to give you anything more. You're done. You're lucky you got decriminalization. That itself, we got it because we thought it's only a narrow point. But then that's become, as these things go, they become, as Justice Scalia put it in Lawrence's Texas dissent. He said, it's very interesting. Huh? He said, I'm paraphrasing. He said it's a slippery slope. You give these guys decriminalization, they will ask for marriage. You can't keep them down. They'll want that next step. And that's precisely what is happening. Navtej is leading to that. Right. But the government's opinion is different. Huh? And I think we'll begin to see that in clearer and clearer terms as the time goes on. So yeah, I'll end with that.
Right. In fact, I feel that because the government is stopped to question what has already been decided in Navdeep Singh, they're forced, like you said, to accept the fact that, all right, you have been recognized. But I also feel that they use it as ammunition when they say that, all right, only to this extent, private acts. But when it comes to same-sex marriages and recognizing the matrimonial right of same-sex couples, we till date have submissions in court as early as last year, where the central government has submitted that it might just lead to an increase in the spread of HIV.
Yeah, shocking submissions. In fact, that's interesting you make this point, because I want the other thing I want to draw your attention to. The submissions they're making in 2021, as you rightly said, are the submissions the same in 2004. There's no difference.
Which means that there has been no growth.
The NDA government today has gone back to the UPA government of that day. The UPA government has changed and developed its position. The NDA government taking a particularly problematic viewpoint as far as LGBT rights is concerned.
Right, which I feel that we're not progressing as much as we're regressing now, with the government sort of accepting first and then relying on.
The point is this: it's regressing because that is the nature of the government you have. Right. It's a regressive government.
Right. But quickly coming to another question, Professor. Now that we've understood the stance of the government clearly, we still feel that, like you mentioned, it all started with activism. Then the judges also intervened, and then we had people who actually have gone through this. The struggles have been portrayed. But till date, we see proceedings, the one like yesterday, where the government has refused to provide for any rights. In such an instance, two questions. Firstly, with regards to Mr. Kirpal's submission that it's a natural constitutional interpretation of the Navdeep Singh Johar judgment that also by extension provides for marital rights to same-sex couples. First, is that true? Second, just by extension, it's a huge question because the court has been silent on this. While on the one hand, the court has expressly held in multiple judgments that choosing your partner is your exclusive domain. At the same time, it's not a legally recognized right for homosexual couples or same-sex couples to sort of choose their own partners. In such a world as we're living in right now, what steps are being taken or should be taken to at least recognize adoption rights, employment rights, or marriage rights, as we're talking about right now, of same-sex or homosexual people in general? I mean, is there any progression that is coming from the people at large? Because we see that the government isn't really taking any steps.
This is going back to our position of how will this right evolve? It has to evolve in a certain way to social acceptance and social practices, which then make their way into the law, right? And that's one direction which it has to evolve. So in one way is, if you have more and more acceptance of couples coming out, couples getting married, obviously without legal recognition, but social recognition, that itself is setting the tone for the future acceptance of this particular right. That's one viewpoint. But the other viewpoint is, Saurav's argument is a good one. I completely concur. If you read Navdeep, you read Justice Chandrachud's judgment, he is all but telling you that that marriage is that if you don't have any form, he doesn't say marriage, you don't have any form of partnership recognition, it will violate your right to equality. Because he is very clear that the question of relationship recognition ties into a range of rights. It ties into the question of dignity, it ties into the question of autonomy and choice, all of which are rights which everybody has under the Constitution. So I think there's no ambiguity in the legal interpretation. So I think this presents the opportunity. I think you should look at it as 2000. If for example, you get a bad or good judgment of the Delhi High Court, either ways it's going to the Supreme Court. Right? Either ways, this is a chance to build a movement around the entire question of equality with respect to marriage in the time going forward. But just one last point, I think just you have to make that in terms of within the community itself, there are very diverse perspectives I hope you know that not everybody is going to go about marriage, saying that marriage is what we want, marriage is we want to go. People, uh, there's the people who believe that the other priorities which the movement needs to have, such as, for example, the question of discrimination faced in workplaces, which you indicated, and a range of ways in which people's right to selfhood and dignity is being marred by various kind of legal frameworks. That's one kind of a struggle. The other struggle, of course, is, is it marriage you want? Is it partnership recognition? Is there other models of relationship recognition which one should be looking at? All of this is there, but I think the marriage question fundamentally for me is a question of equality, right? If that right exists for a certain group, it exists for all people. So that I'm 100% I'm 100% on that line of thinking. It doesn't mean there should be no other imaginations. Other imaginations should be there. People should push for whatever else they want to. But if you're fighting for this battle, saying that you must have the right equality as far as marriage is concerned, you must have 100%. There's no ambiguity on that part.
In fact, I completely concur with you. And my final question is, in fact, a follow-up to your answer. So now that we've understood the judicial perspective, we've understood the perspective of people actually fighting for the rights of the LGBTQ plus community, and we have discussed at length what the government stance is. My question to you is, are we sure that the public perception is also, and I say this with full responsibility, are we sure that the public perception is also pro-rights in this matter? Because while on the one hand we say, all right, everybody's fighting for these laws, it's only the government that is sort of, backlashing and sort of hindering the progress. But at the same time, just a very recent incident that happened this week, for our international viewers, Dabur, a company in India, actually released an advertisement based on a festival in India that is celebrated, Karwa Chauth, which is a celebration of the marital or matrimonial sort of relationship of spouses. The advertisement, instead of the normal conventional husband and wife as a heterosexual man and heterosexual woman, showed two women celebrating the same festival. Now, that was met with a huge uproar by the communities. And so much so that the Dabur, the brand, had to take the advertisement down. So on the one hand, we have activists and we have brands accepting, we have, sort of publicity on a full large scale on national television in favor of rights for the community. But on the other hand, we have certain sections of the society itself that are against giving rights to people or recognizing the rights. So are we really sure, coming back to my question, are we really sure of how great the public perception is of these rights? And is it only the government? And if yes, then how do we progress from here, Professor? My final question to you is, where do we see the future of queer rights in India?
This is a great question. It's a fantastic question, and I think it should be asked. If you look at the post-Navtej scenario, we did a short study again, which is there on the ALF website. It's called Right to Love, second edition, right? And on the Navtej judgment. But what we did was that a look at 2018, 2021. What is the change which has happened, right? And what we found is that 41 cases of the use of Navtej in different courts around the country, and 20 of those cases are to do with relationship recognition. 15 are by women running away, and 5 are by trans people running away with their partners. And they go to court saying that protect us. Right? And invariably, the court has protected the couple, invariably, against what the family wants. But the other sense you get is at the grassroots level, which are very, very right. There's a certain kind of a resistance building as well. Till now, there is the entire question. I mean, where are you from, Sambhav, by the way? Which city are you?
I'm from Delhi.
Okay.
New Delhi.
And I'm in the state of Karnataka, which is in the south, which is the 2,500 kilometers from where Sambhav is sitting. But in the state of Karnataka, our chief minister, who made a statement saying that with respect to moral policing, which is, right-wing goons barging in and preventing boys and girls from different religious communities from having juice, tea, or whatever, interacting together. And his statement was, if people go against certain social morality, there'll be a reaction. For every action, there's equal and opposite reaction. In effect, he said, moral policing can happen. And who have been the target of moral policing till now? till now. It's boys and girls from different religious communities. There is no guarantee that this model policing will not going to affect the LGBT community. And what Sambhav is indicating in terms of the documentation which is emerging, in terms of the Dabur ad and others, is this backlash very possibly can build up. And he's right. If there's a law is one part of the problem, the government is one part of the problem, the larger part of the problem may be a society which mobilizes and says that we will not guarantee you this right regardless of what happens. So in that case, what do you do? I think the only way forward is to build a movement, build alliances with other groups which are under threat, and start coming together, because you're facing a certain kind of what you call a totalitarian threat. A totalitarian threat, I don't mean in a narrow sense. I mean it by imagination of political power, which wants to control intimate decisions. It wants to control who you choose to be with. It wants to control who you choose to love. It wants to control what you choose to eat. It wants to control what you choose to wear. Right? And if anything, the LGBT struggle, if anything, the queer struggle is about fighting for these fundamental freedoms. And we have to see our struggle as linked to a range of other struggles and see how we can take forward our fight against a certain kind of totalitarianism which seeks to impede the realm of personal choice, which is absolutely fundamental as far as queer people are concerned.
I absolutely agree. In fact, to conclude, I would like to say that every struggle emanates from some lack of rights. In this case, it is the very essential, fundamental, basic fact of homosexual individuals not being considered at par with heterosexual individuals. And I feel that this is one distinction that goes against the very constitutional ethos of our country. And we at JURIST with the Humsafar Trust just hope that conversations like this just move one step closer to actually either ensuring that people around the world, and especially in our country, understand the vitality and importance of gaining this knowledge, of understanding the struggle of people, of how every single day people are fighting to only be recognized. What is normal for heterosexual people is actually more than a privilege, and more than a dream for. I mean, we've come very far, and it's all credit goes to people like you, Professor. Credit goes to activists. Credit goes to the judges. But at the same time, this is the time that we need to sort of buckle up and sort of tackle the backlash that comes from institutions, from public, and from everybody that stands in the way of giving rights that are well deserved to the community. That's I think with this we will conclude this interview. It was extremely informative, and I'm fortunate and I'm glad to have had this conversation with you, Professor. If you had any parting remarks, please feel free to let us know.
Yeah, no, I was just two points which I've often been fond of sharing in forums such as this, because often what people feel is a certain sense of at the end of everything, seeing a sense of hopelessness, right? I think it's very important not to have that sense of hopelessness. And for that, what you need to do is, going back to our point, you need to cultivate a sense of community, build those kinds of relationships with other people, because sometimes strength comes in numbers, which individuals sometimes can't take forward by themselves. So there's a need to build that sense of community. This need to also have a sense of hope that that the in the Martin Luther King's phrase, right? The arc of the moral universe may be long, but it bends towards justice. Your cause is just. You are entitled to live a life with dignity, and that struggle, you have to fight that struggle, right? And I think you got it right. You're saying that we need to build that consciousness as the community is concerned, that this opposition by the government is not accidental. This kind of a backlash in terms of the Dabur ad is not accidental. It precedes a coming together of a certain kind of a phenomenon, which is going to have grave consequences for the way we imagine queer rights in this country. And you rightly pointed out,
it's being normalized as we speak, and this is something that we need to fight against.
Yeah, you rightly pointed to the fact that even for example, even the surrogacy bill, This government is very clear. Surrogacy is a right which applies between a man to a man and a woman, right? In terms of a marital context, they're very, very clear of the thing. And again, the phrase in the marriage arguments are very clear. There's a biological man, biological woman. So the opposition is to trans people, the opposition to queer people. There's no ambiguity on that, you know. And so I think somehow that consciousness we need to really build and say, how do we take this struggle forward? You know, what is going to be our imagination of coming together and taking this forward? And the last poem, since you got me started on this note, the poem which actually I found very, very moving was in 2013, right, when he got that terrible judgment. Our friend Akhil Katyal narrated this poem by a Black American gay poet called Langston Hughes in Hindi at a rally, at a meeting, which is called No Going Back, saying that, you know, broadly saying that you have given this horrible judgment, but we are not going back. We're not going back to our closets. We're not retreating for identities. We're going to take the struggles forward. And that the wording of the poem goes something like this. It says, what happens to a dream deferred? What happens to a dream deferred? Does it dry up like a raisin in the sun? Does it run like stinking meat? Or does it explode? And really the point is then, how do you get together to ensure that this dream explodes?
I think it's all about getting back up and living to fight another day. And that's what we've been doing. So thank you again. Thank you so much, Professor. And I'm glad to have had a discussion with you. It was a pleasure having you with us.
Thanks, Sambhav. It's good to have you also come back on many, many points, because I think the discussion was aided a lot by your passion and enthusiasm and your comments, which gave a push as well. So thank you.
Thank you. Thank you so much.